I'm going to object. Yes. And Brigadier Gininda is trying to come with his own analysis. Pointing out is a very specific thing. It's either you pointed a specific thing without there being, without the information that is being interpreted, which is being pointed out being interpreted. Now he is feeding this court what he thinks could have been pointed the day on which the alleged pointing out was made.
When I was listening to him, and I listened very carefully.
Yes.
He says, "I know that spot." That's what he premised.
He is now talking about Basutu Hostel.
Yes, he says he knows that. Didn't you say that, sir?
I said exactly that.
He says, "I know that spot."
I said exactly
that. Is where they say they left, and that is where they say they came back to.
My Lord, he is saying, he's pointing at the tar road, and this tar road is at Basutu Hospital. You can drive now to check if. But what I'm saying, my Lord, if it needs to be...
Mr. Mnisi,
yes, ma'am.
You can argue that.
No, but my Lord, this is not a point to be argued. It needs to be taken up now so that it needs to be corrected. Because the court will then later on come and say, but why didn't you raise your objection then? This is the reason I'm raising this objection.
Under cross-examination, you can put it to the Brigadier that you were wrong by this and this and this.
Am I therefore not allowed to object now?
You want to cross-examine him during the time when he's giving his testimony. I don't know that procedure. So you can keep that evidence if you're saying he's wrong or he's lying to put it strongly.
Thank you,
and when you cross-examine him, you can point out how he's lying.
Thank you, my Lord, but I think this served to check the minds of my colleague and myself as well. Thank you, my Lord.
Okay, yes.
Please, I think Advocate Mnisi will be well advised to read Section 209 of the Criminal Procedure Act.
What does 209 say? Let's read it because we forget these things.
Well, Section 209 reads as follows. Conviction may follow on confession by the accused. An accused may be convicted of any offense on the single evidence of a confession by such accused that he committed the offense in question. And the following part is important. If such confession is confirmed in a material respect, or where the confession is not so confirmed, if the offense is proven by evidence other than such confession to have actually been committed. Now, my Lord, we've been through a trial within a trial. The confessions have been allowed. At this point, what the investigating officer is trying to do is just to try and connect the dots to show that this spot that was pointed out by the accused accords with the objective evidence.
May I respond, my Lord? Oh, I'm sorry, my colleague wants to object. Yes, but I'm also prepared to respond as well.
My Lord, we're all aware of the provisions of Section 219, which the state has just read. The gist of the objection is not on the provisions, my Lord, of Section 219. The gist of the objection is on the explanation that is given by the witness, wherein he says the picture depicted in photo so and so, wherein the accused is pointing, it means it's pointing, and it starts to give the explanation on the description to say it means the accused was pointing at this and this, my Lord. So the objection is on that this witness cannot give explanation to say what was being pointed out or what was being shown, my Lord, because pointing out will have notes to say on this position when the accused pointed this is what was pointed out. It will be recorded there. It does not necessarily mean that the investigating officer has to come and explain to say what is it that was pointed out by the accused, which is not the correct information or evidence contained in that exhibit, my Lord.
How do you say that? You've got the right to cross-examine this witness until Mandela is risen from the dead. That's your right, but you can't stop a person giving evidence like he is evidence in chief and cross-examine him whilst he's doing that. You have every right to cross-examine him. You have every right to put your client's version there. You have every right to interrogate the photos and show him what you are saying. These photos don't show. Okay, you have that right. So
Yes,
please.
yes, I agree, my lord. We do have the right to cross-examination
Yes,
at a later stage.
But you can't stop him.
But also, my lord, as we are the defense representing the accused, my lord.
Cholo,
Yes,
I say you can't do it.
Yes.
At this stage.
Yes, my lord, I'm responding to that, my lord. I said, yes, my lord, we agree with the court that we do have a right to do cross-examination. However, if it appears from the defense that something wrong is happening in court when the evidence is led, we have a right to raise an objection, my lord. If the objection is overruled, there is no problem, we will proceed. But we do have a right to point it out to the court and to raise an objection on the unfairness that is happening in court when it appears to us, my lord. That's my submission.
Yes, okay.
If the objection is overruled, my lord, it should appear on the record that the objection was overruled, then we proceed, my lord. But it shouldn't be as if we left it and it was allowed to go through when we could see that it was wrong, my lord. Thank you, my lord.
So please, my lord, there's no unfairness as my colleague is arguing. A confession or pointing out on its own cannot just stand on its own. It's got to be supported by objective facts, and the only way is if the investigating officers, a spot has been pointed out, that spot accords with my knowledge of the crime scene. That's how you add weight to the confession, because on its own, hence Section 209 says there has to be evidence aliunde or confirmation of the confession or the pointings out in a material respect, and that is what the investigating officer is indicating, to show that there's confirmation, there's corroboration. That's perfectly in order.
Yeah, but as you know, the defense has got the right to cross-examine.
Yes.
Am I correct, sir?
Indeed, my lord.
Yeah. And that right is immutable. I can't stop anybody wanting to cross-examine a witness who has made a certain observation which the defense disagrees with. And you can put it to Brigadier Gininda that he is wrong here, he's not stating the facts. The facts are this and that and that and that and that. Okay, let's proceed.
As a court, please, my lord.
My lord, again.
I wanted to refer my colleagues to comment on
It's a ruling that we can proceed. My colleague says he wants to refer us to something. Is that not an issue for argument as well? Because the manner in which he's doing it, we are going to request tomorrow when we come back that we should counter what he is trying to refer us to by also referring him to certain authorities as well. This is highland procedural. Otherwise, he's overruling the court when he says he wants to refer us to something when the court has said that we can proceed.
He wants to educate the court. You're trying to call the case. We are thinking you wanted to case.
I just wanted to buttress the point, but I'll leave it at that. You can proceed.
Yeah, he needs to be very specific. If he wants to educate the court, he must state it that I want to educate the court, because I'm not interested in his education. I'm educated enough to be educated by him.
Yes, we can proceed, Brigadier Gininda. You were at photo number 19.
Yes, my lord. But my lord, can I just say the following? And because I've said it in my evidence, and I think I dealt with it during the cross-examination on the main trial, on the trial within trial. Photos, as much as they can tell thousands ways, they don't speak. When these confessions was taken, the confessions, the written one, and the photos, I needed to corroborate what was said. That's how you make sense of the confession. You can't take it on the face value and say, this person has said this, it's written there, it's the gospel truth. You must corroborate it. Corroboration means there's a suspect, an accused pointing a scene. Where is this place is pointing? When I said I know this place, my lord, it's because I had to go to these places and corroborate. Where was the car stationed? Where was it placing? Is the place he is pointing collaborate with what we have in evidence? That's how you build a case. Mr. Mnisi was the prosecutor for the state. He ought to know that, my lord. Page photo 21 on exhibit GG1. Photo 21, you can see clearly the hostel behind. The car that was driving the accused, that is accused number 1, is depicted there. Behind it in photo 21, you can see the building of the hostel. So it will not then make sense, my lord, to say, and this is a process I had to embark on to corroborate what was contained in his statement, as well as the statement of accused number 2. And furthermore, my lord, that did indicate that I was looking at this photo album in relation to the notes that were made by the pointing out officer. And I think that deals with what Mr. Mshololo was saying, my lord, that it's not like I was just looking at a document, interpreting it in my own way. I wanted to see if it can be corroborated or not, because that's how investigations are done, my lord. And lastly, my lord, that I've said, I know this place, I stand by that, I definitely know it, and if that is in dispute, we can do the inspection in logo. So Mnisi, they can come, we can go to this place, my lord.
Are you done with the inspection on photos 19 and 20?
Yes, 19, 20, as well as 21, my lord, because photo 21 shows the hostel. You can actually see the buildings clearly of photo 21.
We can go back to your evidence.
Yes, my lord.
What happens after the pointings, after receiving the pointings out form, as well as the photo album?
So, my lord, as I said, I looked at the collaboration, which I've just indicated that I found. They were obviously then filed in the docket, and then we carried on with the investigation, my lord.
That's good. Please, I just want to draw your attention to Exhibit FF. That is the confession in the name of accused number 1, Muzika Kulela Stemba Sibiya.
Yes, my lord. And it is also in the interest of justice, my lord, because in the process of collaboration, if the suspect or the accused is not aware of the crime scene, you will pick that up, because he will refer to scenes that have nothing to do with your case docket. He will mention things that are irrelevant. So it is in the interest of justice on both sides, my lord.
My lord, I think I'm going to object, and I'm raising an objection. Investigating officers, their primary function is to investigate a case and bring objective evidence before court. It is for the court to analyze that evidence. What this witness is now doing is embarking on a process of analyzing evidence, which that should be left for the court after the court has been after the court is seized with that objective evidence that came from the investigating officer. It is not their duty to assist the court on how to analyze that evidence. They are taking over what the court is supposed to be doing. We are expecting Mr. Gininda to say, in the course of our investigation, this is what we found. This is what we found. This is what we found. This which we found is how it connects accused number 1. This is how it connects accused number 2. This is how it connects accused number 3, 4, 5, etc. It is not for him to come and opine as to how the evidence that they found is relevant with the connection of each of the accused persons. It's basically usurping the duty that the court should embark upon after having had all the evidence at the end of the case. I'm strongly objecting to the process that this witness is embarking upon.
I don't know if counsel is saying he's objecting against the process, is he objecting against what he's just said, or trying to link the confession of accused number 1 to the objective facts in this matter. But be that as it may, my lord, what the witness is merely trying to explain is what he explained yesterday. He says there appears to be a misunderstanding, so he's just merely rehashing the explanation that he gave yesterday when Advocate Mnisi was objecting. That's all that he's doing, my lord.
Mr. Gininda, just repeat what you just said so that we all understand you.
My lord, I said, the collaboration of the confession is not the rehearsing of evidence. When a confession is made, my lord, you need to collaborate those facts, and that is in the interest of justice in my view. Because let's assume, my lord, where great injustice can be done, a person makes a confession but you point a different scene, and then because he made a confession you just take it and file it. You don't collaborate as to whether the scene that is being pointed, is it relevant to the matter that you're investigating. You have to collaborate it to find credence, to find evidence and proof, and that is exactly what I'm referring to. It's not a rehearsal of what Colonel Mboto wrote, what Lieutenant Colonel Daparo wrote, and the magistrate is to say After I received this confession, because yes, as Mr. Mnisi rightfully says, I'm the investigating officer, I have a duty to investigate, and I'm presenting the facts that I found when I compare what was contained on the confession statement in relation to the docket. That's exactly what I'm representing to the court. Because if I keep that is, why would I not tell the court to say, when I read the confession that is made by accused number 1, I found this fact, and this fact collaborates with the docket and the crime scene. That is all that I'm saying, my lord. I'm not making a judgment call as to how the court must find the evidence or what it did. I'm simply referring at the duty and the role I did when I received the statement and in trying to collaborate it. That's what I'm saying, my lord.
May I respond and make an example? Excuse me, my lord.
I say, he says it's not exactly my duties. Collaborating.
It definitely does that, my lord. And may I make an example so that as we go forward, my lord, then we are clear on the process that we're supposed to be embarking upon. He testified yesterday, I think, and referred to Mr. Mnisi and said that some witnesses in the house, they got information, or also in the statement that he went through that is contained in the confession, one make of the statement speaks about a person with dreadlocks. And in his view, he specifically said that, and in his view, that person is accused number 3. Should that not be left in the domain of the court? We're not interested in his views. All that we're interested in are facts that he has collected, evidence, my lord. It could be direct evidence, it could be circumstantial evidence, or what other form of evidence, but we are only interested in the evidence that is bringing before court. We're not interested in his views. That is why I'm saying, my lord, he's basically usurping the function that it should be seized with the court. It's basically saying to the court, this is how the court's judgment must be penned. He's penning his own judgment, my lord. I don't know for what, because he's just an investigating officer. He's only here to assist the court with facts and nothing else but facts. Thank you, my lord.
Please, my lord. Yesterday we looked at section 209, which we read in the record, and what this witness is merely saying is contained in section 209. That is the first thing, but all that the witness regarding the fact that in his view, when reference is made to a person with dreadlocks, is accused number 3, all that he's saying is that the evidence establishes that the person who had dreadlocks is accused number 3. And we refer to the relevant photo, which is not disputed, that shows that accused number 3 had dreadlocks. That's all that the witness is doing. And secondly, we indicated, my lord, in the beginning that the version of accused number 1 is that he is not the source of this confession. Now, all that the exercise that this witness is embarked upon is to indicate that accused number 1 is the only person who could have been the source of what is contained in this document. This the exercise that Brigadier Gininda is busy with.
Yeah, this court is experienced enough to sift evidence from witnesses and judge the evidence on the facts as Mr. Mnisi suggests. Now you see this case, here's an investigating officer. He says, among the people who were inside the house, the evidence is clear. It was only supposed, and I'm not making any finding. It was supposedly a person with dreadlocks. There were no 6 guys with dreadlocks, or 10 guys with dreadlocks. And then he makes a conclusion that it must have been accused number what. I'm not bound by what he says, I'm bound by the facts. Maybe there were 20 guys with dreadlocks, I don't know.
I'm indebted to the court, my lord. Now that the court has said that, the court is trained enough to separate wheat from the chaff, my lord. Thank you, my lord. Thank you.
As a good please, my lord, you've indicated in your evidence just before the short adjournment that Mr. Senzo also gave a statement to the effect that accused number 5 was driving a grey VW on the day of the incident. Can I refer you to the record of the proceedings on the 7th of September 2023, page 9,
Yes, my lord.
and from line 16 to 20.
Yes, indeed, my lord. So it reads as follows, my lord. Mr. Baloyi, did you see what vehicle accused 5 was driving on that day? Mr. Zumu, yes, I did. Mr. Baloyi, yes. What type of vehicle was he driving? Mr. Zumu, it was a grey Polo hatchback.
Okay, we can then get back to exhibit double F, the confession of accused number 1.
Yes, my lord.
We're busy analyzing, you can proceed. If perhaps you can have a look at page 1 of that statement. It refers to a date on 2014 between September and October. What is your comment regarding that?
Yes, indeed, my lord. So this date, my lord, the month in particular, refers to the period when this incident took place. More or less, this one took place in October, the 26th of October 2014. And accused number 1 says on 2014 between September and October, so it's close. So this is a collaboration that he was referring to this particular matter. Furthermore, my lord, in the collaboration where he makes mention of the name Senzo Meyiwa, around that period of October 2014, my lord, the only Senzo Meyiwa that was shot and killed in Kosoras is the deceased, the matter that we are dealing with, my lord. In other words, my lord, I'm saying there are no different deceased with similar name and surname that were killed under these circumstances in that area in the month of October or September 2014. It's only this deceased. So an inference can be drawn that he was referring to this particular matter. Yes.
That's another objection. This witness simply refers to an inference. Who is seized with that functionary of drawing inferences? It is not him, because that is not a fact. What he's presenting now, he says an inference can be drawn that it was. Now, I'm not even so sure whether he's aware of R versus Blom on the drawing of inferences. So he can't just stand there boldly and say an inference can be drawn that it is him. It is for this court, my lord, to deal with the question of inferences after the state has requested that the court should draw a particular inference, not a witness who is an investigating officer. Him is to bring facts before court, not to tell this court that it should draw inferences. This is highly irregular. Thank you.
I think the court has already commented just a short while ago that the court is trained to separate opinion and inferential reasoning. I think all that the witness is saying, my lord, is that the name of Mr. Senzo Meyiwa is being mentioned here, which is what this case is all about. But I'll request the witness to refrain from making any inferences and just give facts. Yes.
My lord, I've noted, but I think Mr. Mnisi is really quoting me out of context, and I left it the first time, but I see now he's continuing. First he said, I gave an opinion or something to that effect that no one in the house, like it was my view, that accused number 3 was the one with the dreadlocks. He didn't refer as to under what circumstances.
This is the court, madam. Mr. Baloyi is a prosecutor, he is a witness. Oh, thank you. No, but what I'm saying, my lord, is under the guidance of the prosecutor. He just can't just do things willy-nilly, my lord, like a wanton sheep. As a prisoner.
However, my lord, if I may just ask my lord leave to make just a few submissions, my lord. If there is an objection, my lord, between counsels, the objection is between the parties, the defense and the state, and the ruling will be from the court. The witness is not allowed to get inside and give explanation unless it's invited by the court to do such, my lord. Thank you.
Yeah, just finish what you're saying.
Yes, my lord. So I was saying, my lord, that is out of context because the facts of the matter contained in this docket, and these are the facts, they point that the person with the dreadlocks who went inside that house is accused number 3, Mr. Mnisi's client. There are statements in this docket. So to say I'm making whether an assumption, an opinion is selective in that, and I don't think it's in the interest of justice, my lord, with greatest respect to him, because he's sitting with the facts that point in terms of the statements. Mr. Zungu, Sizwe Zungu, I mean, it was before this court, I was not here, but the statement indicates what he knows. The firearm that was used as a murder weapon is linked to accused number 3. He's
Objecting, my lord. That is totally irrelevant. That is totally irrelevant for this moment. How does it say that the firearm is linked to accused number 3 when that aspect is being investigated? No, that is totally irrelevant, my lord. And this witness, my lord, is going to tell disrespectful to this court because they can only speak to the court through the prosecutor. What he's doing here is total disrespect of this August House. And I'm going to request the court to tell him to refrain from doing that. Because now he's saying the firearm in question here is linked to accused number 3. Where does he get that from? Where does he get that from? Because that aspect is still being investigated. It's total disrespect.
So we'll get to those aspects, Brigadier. Not if I can then ask that we return to Exhibit F.